Thank you, Your Honors. May it please the Court. Thad Spalding on behalf of the appellants, Rogelio Carlos and Myrna Carlos. The issue is pretty straightforward for our purposes. It's purely whether our expert, Dr. Scalabasi, was properly excluded, whether his testimony was properly excluded. And it focuses on his practice area, which is neuromonitoring. And so it'll help to kind of understand what neuromonitoring is in this context. Neuromonitoring is, in Dr. Scalabasi, the reason we kind of got him as our expert in this case in the first place was, and we call him this, but he really is the grandfather of neuromonitoring. He's not by any stretch of the imagination a professional expert. This is what he does. And he actually created this and works continuously on this technology, and it's intraoperative neuromonitoring during spinal surgeries. And what this does is it can be done remotely like it was in this case, but it's a neuromonitoring physician. There's usually a technician in the operating room, but there's a physician that monitors the signals being given from the spinal cord. And if there is an interruption in those signals, or certainly a cessation of those signals, then he is to alert everyone, and at that point, the surgeon can take some action. And there's really no dispute, and even the magistrate judge had no problems with his qualifications as far as examining the standard of care and breach. The only issue became causation, and whether he could say what he wanted to say, which was that had Dr. VanNess alerted Dr. Bruggeman, who was the surgeon, in a timely manner, he could have gone in there while Mr. Carlos was still the wound was open, and he could go in there and he could take out this bone fragment, which was compressing the spinal cord.
So he's talking about the neuromonitoring doctor and something had he done, and he believes that helped with the causation.
That's correct. Yeah, he's addressing. He's a.
The surgeon didn't do a good job in removing the bone fragment.
No, in fact, nobody's got a question.
The problem is the causation is what would the surgeon have done, right?
Well, true, but we know what the surgeon would have done. And, I mean, the surgeon would have gone back in and removed the bone fragment, which is what he did once he found out about the issue with Mr. Carlos's lower extremities. But the problem was Why
don't you have that kind of surgeon do expert testimony on causation?
Well, because the link is not, the link for our purposes, for the neuromonitoring physician, is the link between the neuromonitoring physician's breach and the paralysis. And if there was an issue as to what the surgeon did or should have done, I agree, we would have needed a surgeon. But in this case, no one's complaining about the surgeon, and we know we have the surgeon's testimony. Dr. Bruggeman was pretty clear, well, I wouldn't say clear, but Dr. Bruggeman testified that once he knew about this issue, he went back in and he found the bone fragment and removed it. The issue was at that point, it was too late. It was too far down the road to save Mr. Carlos from paralysis.
Ask him if he had done it earlier, what might have made a difference?
We asked him if he was asked if it could have been done earlier. He said he would have gone in, he would have done it, but he did not. Right, exactly.
They asked if it might have been more successful had he been able to do it earlier.
No, because I'm not sure he's the guy, I'm not sure he's the expert that can address that. He can address the mechanics of the operation and how he went in, how he conducted the operation.
But if you needed the person who did the operation, assume arguendo, then it seems like you just ask him that question and he'd say, yeah, I didn't get the information in time.
Right, but the neuromonitoring physician, he's the physiologist. He,
I'm not disagreeing with
right.
just saying as a backup.
Yeah. Well, yeah, I mean, but I think looking at the circumstances, I mean, there's at least support for that causal connection, at least as far as the how and why that's required in medical causation testimony, because you've got the surgeon had, and this is kind of the standard of care, has become the standard of care, is having the intraoperative.
A lot of experience on this court about medical malpractice.
Oh, I agree.
Supreme Court.
Right.
In this courtroom, and it may seem stingy, but sometimes they require you to have 3 or 4 experts for every single aspect of something. Like in a nursing home care, you have to have the nurse and then the soup administrator, and they bring 4 or 5 experts, and then it costs a lot of money to bring a case.
Right.
But that has been the drift of the law in the Texas courts, hasn't it? And do you have any case that would say that this is good enough under Texas law? Are we not in Texas law? I thought
No, this is Texas law,
okay.
for sure.
Is that because you kind of looked at me?
No, and there have been, this is, at least in the medical malpractice landscape, this neuromonitoring malpractice is relatively new. I could find 3 cases that even address the issue, and unfortunately they all address it in the Chapter 74, the early expert report issue. And so, I mean, they deal with neuromonitoring, and they involve...
People who don't have a report from the surgeon?
No,
They say it's okay.
they say it's okay. They say it's okay to have a neuromonitoring, and I can provide the court with the cites to that case. And
They say that's an adequate expert on causation?
they say that a report from that, yeah, and drew the sufficient link on causation as far as timing or as far as cause and effect.
Those cases in your brief?
No, well, one I just found this morning. It was from just a couple of months ago.
When you find a case on the eve of argument that you file, will you alert the other side?
Yes.
Because that's collegial and appropriate, and you file something called a 28J, and then the other side has a chance to file a 28J that says that case isn't on point, or I found this other case, and it rebuts that case,
Right.
So that's what needs to happen.
Well, okay.
That needs to happen within 3 days of the argument, and then they'll have 3 days to respond.
Will do.
Okay.
Does the record have any other evidence of causation besides Dr. Scalabasi?
No. It is Scalabasi's testimony that connects, that involves the timing. Now, his causation testimony is based on, more than just we kind of got hung up on this chart, but there's the signals that have been given off, on the chart, on Dr. VanNess's chart. He also relies on Dr. Bruggeman's testimony to draw that causal link. But no, Dr. Scalabasi is the beginning and end of the causal
Okay.
link. And he's the one, and getting back to Judge Elrod, I think your question was, he's the one, at least from our perspective, that's in the best position to draw that causal connection. That the surgeon, certainly this is in place, but the neuromonitoring physician knows the physiology of the spinal cord and knows that when there's a compression impact on the spinal cord, here's the, how much time you have, and this is why this monitoring is in place. And so if you don't do something within a certain amount of time and alert the surgeon, and give the surgeon time to take corrective action, then there can be a bad result. And so I think there's not a qualification issue here.
Right, but knowing what the surgeon can do, don't you have to be that kind of surgeon? I mean, I'm looking at the appellee brief that says Dr. Scalabasi disclaims any qualification to render an opinion as to surgical technique or standard of care, or the qualification to diagnose the cause of the spinal cord. I mean, the problem here was, I understood Dr. B to Bruggerman, I'm not very good at these pronunciations, but Dr. B to say he wasn't really sure he could have seen the fracture.
That's correct.
So the notion that the neuro person can be like able to figure out what the surgeon will do and how long that'll take and all that, I'm just struggling with that.
No, and the surgeon, and I think the surgeon is not as unequivocal about what he could or could not have seen. When he went back in, he had the benefit of the CT scan, opened Mr. Carlos back up, and was able to remove the bone fragment. But he did not say that he absolutely could not have seen the bone fragment had the wound still been open and he been alerted to the signal. He said it might have been difficult to see, but he never said that he couldn't see it. And so I think there's at least evidence from Dr. Bruggeman that had he been alerted to the problem, he could have gone back in there and removed that bone fragment, which is what he ultimately did.
But the issue here seems to be more about the timing and not, so for example, if he could have had, 2 weeks to get it done, this wouldn't be in play. Okay, so the issue is the timing. Why isn't that something that only the surgeon would know as opposed to the neuromonitor?
Well, again, I don't think there's no issue with regard to how long, once the surgeon was alerted to the issue, how long it took him to get back in there. And so the only discussion with regard to causation is, had he been alerted during the surgery, and the signals that were lost.
I thought this 20 minutes was a big part.
Oh, sure.
Of what you all were contending.
It is. Okay. And
I'm just struggling with how Dr. Scalabasi knows that when he's not the surgeon, and he admits he's not, and he disclaims any such qualification and so on and so forth.
Yeah, and he states that he thinks that he would have been able to go back in there and find the bone fragment because of what he did later. So he's not, and I think in that sense, we're relying on the surgeon to tell us that.
The surgeon states that.
The surgeon states that.
But he could have gotten it earlier.
Well, he says, if I had been alerted to the loss of signal, I would have gone back in there.
Oh, well, why isn't that the causation test? Why isn't it both the surgeon and the neurotransmitter?
I think it is. I mean, I think it's because the surgeon says what he says, and we're relying on what the surgeon says he would have done.
What is the best thing he said to help you?
He says that
because he did go back, and he did the CT scan and all of that. So, I mean, that all happened. But the timing seems to be your argument. What's your best site, the ROA site or whatever? What's the best testimony that gets you where you're trying to go?
He says that if notified during the surgery, he would have removed the equipment and looked inside. And that is at ROA 6286, page 109 of his deposition.
But then, did he say, and then it would have been okay, wouldn't have been paralyzed?
Well, no. That's where Dr. Scalabasi comes in. He's given the window of time. We're relying on the surgeon to address the mechanics. And the surgeon has said, if I was alerted to the loss of signal, I would look back in there.
But he did look,
right,
ultimately, and wasn't able to prevent the paralysis. So I'm not understanding how Dr. S knows the timing.
Well, the timing is, the facts set out the timing. I mean, the surgery ends at a certain point, and Mr. Carlos the wound is closed, and everybody goes on about their business. And Dr. Bruggeman, the surgeon, doesn't open Mr. Carlos back up for another 3 hours. And so at that point, it's too late. But while you're still in the surgery, what Dr. Scalabasi says is you have between 10 and 20 minutes to remove the compression.
that information, that is not just what is my standard and what am I supposed to do, but that makes all the difference. How does he know that?
That's based on his experience as a neurophysiological monitor, based on his review of the data, and based on his experience handling these kind of surgeries and the monitoring, is that there's this window. Physiologically, there's a window by which a compression injury needs to be relieved before permanent damage is done. I see I'm out of time.
Thank you. You've saved time for rebuttal.
May it please the court, I'm Vaughan Waters here on behalf of the appellee, Dr. William VanNess. As we've seen, this is not an appeal about standard of care or breach or damages. It is an appeal about one element of a Texas Medical Liability Act cause of action under Chapter 74 of the Texas Civil Practice and Remedies Code, and that one element is causation. Every aspect of—
But what is your response to the notion that Dr. B says, I would have looked at it then? And doesn't that matter? I mean, waiting around several hours can cause a paralysis that otherwise would not have occurred when your client violated his standard of care.
Your Honor, again, we're not disputing the issues on standard of care, but the very important thing, the crucial thing to bear in mind on the timeline here is what happened in the initial surgery. One thing that I don't think was made clear in the appellant's argument was that Dr. Scalabasi had not yet finished closing up the wound on the initial placement of the hardware at the time the report came in from Dr. VanNess's office on the unusual evoked potentials, the EMG, electromyography, and the SSEP, somatosensory evoked potentials, I believe is the term that's used. He was still in the operating room when that came through, and in fact, the appellants actually formatted this and provided this on page 5, I believe it is, of their reply brief when they copied this from the log notes that were taking place. They were still in the process of closing up that suture, and in fact, Dr. Brueggemann, the orthopedic surgeon, had not yet left the operating room when those reports came in. Now, the timeline here is crucial because what happened when Dr. Brueggemann received that information? Well, he did several things. He first ordered a neurological exam, which turned out to be normal. He then ordered a second, what he termed better, neurological exam that didn't look quite the same. And so after conducting these two exams, and of course, Mr. Carlos is in post-op by this time, after conducting those two, he decides, I need a CT scan. So he took him down, accompanied him to the CT, looked at the imaging, and when he looked at the imaging, this is Dr. Brueggemann's testimony, that's when he saw the bone fragments. He said it was very clearly visible through the CT. The reason why Dr. Scalabasi's proffered causation testimony is not reliable is because it is based entirely on the assumption that had Dr. Brueggemann been more timely involved in trying to basically recuperate what he had done on tapping that mallet and causing the bone fragments to shear off, if he had been more timely advised of this by Dr. VanNess's office, then he would have skipped the two neurological exams, he would have skipped the CT exam, he would have gone back in, and he might have been able to see those bone fragments anyway.
But I thought the point is that, so you can correct me where my understanding is wrong, because I thought Dr. Brueggemann said that before he closed him up, if he'd have known about it, that he would have removed the equipment that was causing the compression right then. He wouldn't have, I mean, there wouldn't have been a need for all this go back and run all these tests. He would have just removed it right then.
Well, if you look at pages 136 and 137 of Dr. Brueggemann's deposition that was put into evidence on these motions, he says that he had not yet left. In fact, let me just turn to that here.
It doesn't matter whether he left the operating room. I'm asking about while the surgery is still going on. Mm-hmm. He said, did he not say that that if he had learned it while the surgery was still in process, that he would have removed the equipment that was causing the compression right away?
Actually, no, he did not. He was asked, I believe you said, this is addressing Dr. Brueggemann, I believe you said at some point in time you received notice from National Neuromonitoring that there was an issue. His response, correct. Okay, you were still in the operating room? Correct. What did they tell you was the issue? That they had lost the cortical and subcortical SSEPs. But did they tell you exactly where the problem was, or was it that there was just a problem at some point in time with the loss? Well, these aren't, and this is his reply, well, these aren't very specific monitors, meaning there's no way to monitor for every individual nerve root. You monitor a set part in the hand and a set part in the foot, and you just check to see if there's anything that's going through. And then he goes on at page 137 to testify what happened after he had been advised of this
That's not
problem.
the part where he said what he would do that your colleague, just your friend on the other side, just pointed us to. So did he make that part up? I mean, I'm not casting aspersions, but he said that the doctor said he would have done something right then had he been told during the surgery. You keep talking about after they're closing up or while he's still in the thing and what actually happened. And I'm asking questions about what he said he would have done had he learned earlier. I'm not going to say more timely, I'm going to say earlier. So I'm not saying time, whether it was timely or not.
Well, I'm not suggesting in any way, shape, or form that counsel has misstated the record. There may very well have been something in Dr. Brueggemann's testimony somewhere where he's talking about what he would have done.
That's
but what we're talking,
isn't it?
Well, not when he talks about what he did in fact do. I mean, what is
talking about what he would have done had he had the information during the surgery, which is the whole reason that that's the causation. He would have done something different that
Yes.
would have made a difference had he had the information while the person still opened up on the table.
I understand what you're saying, Your Honor, and I believe the answer to that is to go back to pages 109 and 110 of Dr. Brueggemann's testimony. And when we go back to these pages, give me just a second to... When you go back to these pages, what you do say is if we'd had the motor evoked potentials and after replacement of the C5, C6, I'm just speculating on what would have happened then, okay? After C5, 6 placement, there's no changes. Let's say that in this case, potentially there's changes. Then at that point in time, you'd remove the device and take a look at it. You basically go back one step. This is Dr. Brueggemann's testimony. We do that in other surgeries too. And that
Giving the hypothetical that had he known that it was whatever at the C5 and the C6, that he would have removed the device.
Well, that's not exactly the case because, well, he would have removed the device, yes, but what would have happened after that is completely uncertain because his very next answer was as follows. We'd look at it through the microscope after he's removed the device, okay? My concern in this case is that we may not have fully seen these fracture fragments because some of the way they were displaced, it wasn't readily obvious. This is the crucial part, had I not seen the CT scan, I'm not certain that I would have found the fragments.
He say with medical certainty that he would have left it removed.
Absolutely, that's it. And the important point here is not only that, not only was not Dr. Brueggemann not able to say to a reasonable medical certainty that he would have found this, but Dr. Scalabasi could not say so either. And in that regard, when we look at Dr. Scalabasi's testimony on this point, and for this we go to pages 129 and 130 of Dr. Scalabasi's deposition. He is asked, now in your training, education, and experience, what is it that allows you to render the opinion that the bone fragment would have been revealed had Dr. Brueggemann chosen to assess, remove the hardware, and explore? And that's really the $64 question in this whole case, I believe. Answer given by Dr. Scalabasi. I don't say it would have been revealed. I said likely have been revealed, so it's a probable, realistic statement. Question, well, do you believe that it's probable that it would have been revealed? Okay, now is when we get to the opportunity to talk about reasonable medical probability. But his answer is this. I believe that there is a probability that it would have been revealed. I don't know if it's 50% or 40% or 60%, but it's something which should have been explored. Question, can you testify under oath here today that in reasonable medical probability that the bone fragment would have been discovered had Dr. Brueggemann assessed and removed the hardware and explored the wound? Answer, I can testify, and remember, he's been given the words reasonable medical probability. And here is his answer. I can testify that there is a probability that the bone fragments would have been observed. Question, but you can't say that it's better than 50% probability? Answer, I don't know what the number would be. I know that there is a number, but I don't think anybody knows what it would be. Question, so it could have been as little as 20%? You agree? And what was his answer to that? It could have been as little as 0%. Here's what Dr. Scalabasi is really saying, okay? What he's saying is that if Dr. VanNess had performed according to the standard of care that applies to his office and had timely sent back the neuromonitoring results to the surgical team while Dr. Brueggemann was still actually in the hardware placement, if that had happened, then there's a chance that Dr. Brueggemann would have gone back in and he would have found, somehow, fortuitously, found those bone fragments. But because he didn't have those reports from Dr. VanNess's office, because Dr. VanNess breached the status of care, the standard of care that applied to him, Mr. Carlos lost that chance. Now, members of the court, there is, as you say, a lot of medical malpractice expertise and experience on this court. Under what's known in Texas law as the loss of a chance doctrine, if a patient would have had no more than a 50% or less chance of survival, but for the physician's negligence, there is no cause of action for that that's recognized in Texas law. 50% or less. And that's talking about loss of life.
Right, and this is paralysis.
And this is paralysis. That's correct. And I think when you look at...
You're saying this test applies across the board, not just to death.
Well, I think certainly the theory applies. We're no.
It's never applied to anything other than, because the idea is the person will die anyway. It's not that you get a less than whole recovery from. It's not about that. It's about you're going to die anyway. So it's unique to the dying category.
Well,
has that test has not been applied outside that
I have not seen the case where, but I mention it as the analogy that applies here, because what they've got,
Well,
what
because
Dr.
this is a little bit different, because he's going to have the paralysis anyway, unless you can show that that window would have been enough.
Exactly.
That's why you're relating it to the death as opposed to just kind of the general world where I get a little bit more sick than I would have been or whatever. That's more complicated than live or die.
Exactly.
I mean, I
Would
think
the
that's
window
what
have
you're
been enough?
arguing. I'm not saying that's what the Texas standard is. I'm just saying that sounds like what you're arguing.
Right. The real argument is, would the window have been enough? And can anybody say to a reasonable medical probability, which I think we all agree is the standard, can anybody say that that would have been enough to avoid paralysis in this case? Dr. Scalabasi was given the opportunity because he was
Because
questioned.
there's no argument that the fragmenting would have been stopped. The argument is it would have been removed.
Right. They freely acknowledge and even asserted that there is no dispute as to what caused the injury that eventually resulted in Mr. Carlos's paralysis. That was caused by Dr. Brueggemann. That would not have been so. Exactly.
The question is just what's the effect of that?
Right. Could we have prevented what I guess in essence amounts to what they're saying is the supervening cause of Dr. VanNess's failure to timely notify? And the problem is they don't have anyone who could say to a reasonable medical probability that that would have happened. The only thing that Dr. Scalabasi could say is that there was somewhere between a 0% chance and a 60% chance that that might have happened without the CT scan.
What I'm hearing you say, though, is that it's not really to say, well, it's not in his expertise. We're saying that he can't even say it within his expertise.
Exactly.
So we don't have to reach whether this neurotransmitter expert is good enough, has the right skill set, I shouldn't say good enough, has the correct skill set as a doctor to say whether it would make a difference, given the fact that they're in surgeries and this is what they're monitoring for. It's that he didn't say it
Well,
when he had the
didn't.
chance. So isn't that enough to rule? I mean, that's a kind of a, you would be happy with that rule
Well,
too.
correct, and I think that is.
Not whether or not he would have been qualified, but whether or not what he said is enough to get you past summary judgment anyway.
Exactly.
Even accepting his testimony in whole, total.
That's correct, Your Honor, because bear in mind, the basis, the ground of the summary judgment motion was no evidence on causation. They had every opportunity to present evidence. They designated no one other than Dr. Scalabasi as a causation expert on this. They kind of did, I suppose, a little bit of a pivot in their reply brief where they were arguing or seemed to argue that, well, we don't really need Dr. Scalabasi to testify about what a reasonable orthopedic surgeon would have done because Dr. Brueggemann is there, and we have his testimony. Well, we know what Dr. Brueggemann did. We know that once he became aware of these reports from
He's not rushing.
Well, once he became aware of that.
When he became aware, Dr. Brueggemann did not rush.
Exactly. What he did was
That's kind of critical.
Absolutely critical, Your Honor. First, he did a neuro exam. Then he did a second neuro exam. Then he did the CT, and it was the CT that told him where the bone fragments were. But by this time, I think he testified it was at least an hour and a half after he had initially closed up before he got back in, following the CT, and then located the bone fragments. And that's way outside any time frame that Dr. Scalabasi had indicated would be adequate to avoid paralysis on the case. So really, you've got...
You are still of the position that Dr. Scalabasi is not a proper expert on this, but you're just conceding to Judge Elrod that, assuming arguendo he is,
Yes.
that we still can rule on this notion that he hasn't given us anything
Right.
that would show.
The result is still the same. And I have to say also, to Dr. Sklobasi's credit, I think he was pretty candid in answering that question. When he was given the chance to say reasonable medical probability, he was pretty candid. No, I can't say that. All I know is that a chance was there, some chance, and we lost it. We lost that chance.
But why can't he testify as to what surgeons typically do? I mean, given his experience working with surgeons in this context, why can't he testify as to what surgeons typically do? And he did, and he said, quote, "They act on them," unquote. When he tells surgeons about changes in the signals, he says, quote, "They act on them." So why can't he testify as to what surgeons typically do, given his history of working with them?
Well, we don't deny that he knows a lot of spinal surgeons, and he's undoubtedly talked to a lot of spinal surgeons, but he did disclaim specifically that he is qualified to express an opinion on causation as to the cause of a spinal injury resulting from surgery, resulting in what the orthopedic surgeon does or fails to do in that surgery. And he said, no, you don't want me to talk about that. I can't do that. And he was, again, very candid in saying that. But of course, again, we know what happened when Dr. Brueggemann was informed of this and what steps he went through. Why did he feel that not one but 2 neurological exams were needed before he got to the CT? How long was spent on the CT? Why the appellants never sued Dr. Brueggemann? We may never know the answers to any of those questions.
Okay.
But all we need...
You have your argument. Your time is up.
Thank you, Your Honor. Thank you.
Mr. Spalding, you have saved time for rebuttal.
Thank you, Your Honor. Real quick, let me clear up a few things. First, with regard to what Dr. Brueggemann knew at the end of the surgery, there's a dispute, and this is part of our standard of care and breach, as to what was actually told to him. And while he testifies that maybe he knew about some issue with signals, he did not know the degree of the loss of signal. And that was part of the complaint as to the standard of care and the breach, which was Dr. VanNess did not relay the severity of the loss of signal.
So even then, that he didn't know, still know, and so if he'd known the whole thing during the surgery, the answer could be different.
Yes.
Okay.
And can you cite to us what he says on that?
That gets back to what Dr. Brueggemann says.
Right, that your opponent was citing, pages of the deposition. I'm asking you if you can cite us what he said on that.
And that the same section that Mr. Waters cited to Dr. Brueggemann's testimony, pages 109 and 110, which is what I cited earlier in my opening at the specific record reference is 6286. But that's where Dr. Brueggemann says he would have gone back in. The 0 to 60% chance, that's not, and Dr. Sklobasi hasn't taken the position that he's going to testify as to what the surgeon would have done, again, because we're relying on what the surgeon said. The reasonable medical probability that Dr. Sklobasi testifies to is the window, is this window of time that he had to act on the compression injury to the spinal cord. Because this is not an acute, this is not I
thought you admitted somewhere that if we affirmed the notion of Dr. Sklobasi not being a proper expert, that you lose the summary judgment. Is that not true?
Well, if Dr. Sklobasi is excluded, then we have no expert. And
okay.
So, yeah, I mean, we've always
excluded on causation, obviously.
Yes.
You have the standard of care and all that, but excluded on causation, then so you win or lose based on Dr. Sklobasi.
That's correct.
Am I pronouncing him right?
Yes, you got it. Yeah, and so Dr. Sklobasi gives us the window of time, and then the window of time exists during the surgery while Mr. Carlos is still open, And Dr. Bruggeman testifies that had he given the information that Dr. VanNess should have given him, he would have gone back in. And that gets us the connection. This is not the loss of chance. He would not have been paralyzed. He wasn't going into this surgery having already been paralyzed a little bit. I mean, this wasn't a foregone conclusion as a result of this surgery. I mean, one of the purposes, it was certainly a risk of the surgery, but...
How often does this happen, that the effect of the surgery is these fragments from these fractures?
Well, enough that it's a disclosed risk of the surgery, and that these, certainly while they're hammering, equipment onto the spine, you can fragment, and that's why you have the neuromonitoring physician monitoring these signals, because that's what you hope to avoid, and that's what they hoped to avoid in this case, but for Dr. VanNess's negligence. And if there are no more questions, I'll give back the rest of my time.
Thank you.
Thank you, Your Honor.
We have this case and it's submitted. We appreciate the arguments from both